2019 to do an interview of Gordon Bonnyman for the Legal History Project of the Nashville Bar Association. So Gordon, please give us your full name for the record, your date and place of birth, please.
George Gordon Bonnyman, Jr., born in Knoxville, Tennessee on September 30th, 1947.
Okay. Gordon, we'll get to some of the details of your early life in a minute, but in the Bar Association outline of the interview, and Roman numeral 3 is to talk about a career overview, and why don't we just talk about that now. You graduated from UT Law School in 1972 and were admitted to the bar that fall. And after a couple of other stops, you then started working for the Legal Aid Society, or Legal Services of Nashville, as it was then known, in March of '73. Tell us about your first day on the job and your early work there.
Well, I had tried to work for legal services before that. I'd gone to law school because I wanted to do legal services work. I was really taken with that. And I'd heard a lot about legal services in Nashville as a very respected organization that was doing great creative work, and I contacted legal services all over the country, and it was at a time when they were all short of funds and facing possible extinction politically, and got no responses anywhere. And then I heard, while I was taking the bar exam in Knoxville, the bar review course, with a friend of my wife's from Morristown, that he knew the people that ran legal services of Nashville, and they were good people, and they'd be interested in my qualifications, which incidentally I had none. But he put me in touch with Walter Kurtz. And I called Mr. Kurtz, and he said that he would be delighted. He'd heard about me from Gary Blackburn, and he'd be delighted to interview me and to come right over. And so I drove over to Nashville. This was unbelievably exciting to me because for 4 years I'd wanted to do this work, and it was looking like it just were no jobs to be had. And now I was going to find a job right in Nashville with this exciting organization. And I came over and interviewed with him. The interview went well. He showed me around the offices in what was then the Sudicum building at 6th and Church, and introduced me to another lawyer there named Tom Daniels, who was surrounded by law books in a very impressive looking federal library. It even had that title on the door. And I asked him, what kind of big federal class action civil rights suit are you working on? He said, well, I'm actually looking to do research whether under the Supremacy Clause of the Constitution, since these books were purchased with federal funds, they would be somehow protected from being repossessed by the West Publishing House. Well, that should have been a clue, but it wasn't. I didn't register with me. And so I accepted Mr. Kurtz's offer. And right after the bar exam was over, came over to Nashville. We moved. Claudia, my wife, transferred from UT Law School to Vanderbilt Law School, and we moved over here for her to go to Vanderbilt and for me to take that job at Legal Services, at which point I discovered that Mr. Kurtz actually was not even admitted to the bar yet. He graduated from Vanderbilt a month before I interviewed, at the same time I graduated from University of Tennessee. Mr. Daniels, who was doing all that impressive federal library research, was also newly minted graduate. Everybody there was a newly minted graduate. Mr. Kurtz had no authority to hire me, and in fact, the organization had a budget crisis, and it was not clear whether it would have any staff at all going forward. So that was, I don't know what you'd call my first day on the job. My first day on the job was to learn that the guy who hired me had no authority to hire me, and it was just all make-believe. Fortunately, in March, through a grant from the Ford Foundation, Vanderbilt got money to start a legal program, a legal clinic program, and Junius Allison, a wonderful person who had run the National Legal Aid and Defender Association, was hired as a professor at Vanderbilt, and put out the word looking for somebody who would be able to teach students in clinic about how to handle civil cases for low-income clients for a 3-month grant. And needless to say, there were not very many people with law licenses looking for a 3-month gig that would start in March and end in June when the funding ran out. But it was a job doing legal aid. In fact, it was going to be housed at the Legal Services of Nashville office, and I would basically be functioning as a staff attorney there but teaching students. So I was thrilled to get the job. I had no competition for it. Junius was impressed with my qualifications, as was Mr. Kurtz, in that I had a body temperature of 98 degrees and a law license, which was really as much as he could hope for in the circumstances. So when I showed up at the end of March to take this job, it was you or Mr. Kurtz or one of the other distinguished lawyers thrust a piece of paper in front of me that was on 8.5 by 14-inch paper back in those days, and said, do you want to go to federal court in a big civil rights case, class action involving conditions at Clover Bottom, which is a large state institution for people with intellectual disabilities? And I said, that's great. He said, well, just sign here. So that was my first piece of paper that I signed, my first entry into the federal court. And it turned out to be a motion to propound interrogatories, which was an obsolete document because that had been done away with 2 years before, and you no longer had to get court permission to do that. Judge Clure Morton graciously just scrawled "granted" across it and didn't add an editorial comment about, you nincompoop, look at the rules. So that was my first day on the job. A few weeks after that, I had my first truth in lending case, and on behalf of someone who had been fleeced by a used car dealer, and I was thrilled to use my legal skills to recognize the issue as truth in lending violation. And the way I knew it was that someone had told me the truth in lending law had taken effect a couple of years before, and I saw that this document was printed on a form with a date in the 1950s, and I said, bingo, I found myself a truth in lending case. So that was my early tenure.
Well, since you have begun with the Seville case, why don't you describe that a little more and what was involved and sort of the factual situation and what we were able to do in that case?
The case was called Amy Lynn Seville versus Treadway, and it had been filed a month or two before I got there. It was, as I said, a class action challenging the conditions out at Clover Bottom, which is out in Donaldson in Nashville, or was. It was closed within the past couple of years, finally. At that time, it was a classic, old-fashioned state institution, really a snake pit. The allegations in the complaint, which had been filed, by the way, as next friends by several young orderlies or aides at the institution on behalf of people who were not competent to file on their own behalf. And it alleged such things as being chained to radiators on open wards and tortured with lit cigarettes. The plaintiffs, some of them had come in with relatively good verbal skills and had become nonverbal within a matter of months. You'd go on the open wards out there and you'd see people who are so lacking in any kind of stimulation that they would just be sitting and rocking. It was really terrible. And so the point of the suit was to try to address those conditions, also to try to move the state in the direction of what was then called normalization, would now be called integration, which was to develop community-based programs rather than rely on large institutional settings, which were really a throwback to the 19th century. And we also challenged the process by which people were admitted to that facility. There was an archaic law that said that someone could just be volunteered into the institution, and then because they were voluntary admissions, they didn't have to go through any kind of legal process. We challenged that, and that part of the case was heard by a 3-judge federal court, and we prevailed. I remember in working on that, going through, we got admissions records for the class, certified as class action, and we compiled from those records a summary of the sketchy information that was on them. They might have just been nothing more than a single sheet of paper, an index card with the person's background. We're talking, this is in the early 70s, so we were talking about going back into people who had been maybe admitted as early as the 1930s. I remember memorably one woman who had been there since shortly after World War II, and she had been admitted, quote, volunteered by her husband when she was then a young woman, and you were supposed to write down what the behaviors and the problems were that prompted her admission. It simply said she's fighty, F-I-G-H-T-Y, and stubborn, close quotes. And that woman had been basically incarcerated there since the 1940s, nearly 3 decades. And so we prevailed on that, and we then found ourselves way over our heads in terms of knowing how to litigate a complex factual case like that. We ended up negotiating a settlement, but it was not very effective. It
well, the Department of Justice wanted to come in and help us, didn't they?
Yes. We had thought that the Department of Justice would come to our rescue, and ongoing negotiations, and being the federal government, it took forever. Meanwhile, Judge Morton, L. Clore Morton, who was the judge on the case, believed in moving his docket. And he set a trial date. You couldn't get it continued. We saw this looming. We were deer in the headlights. We had no idea how to try a case. Everything I knew about trying a case I'd gotten from watching Perry Mason on television in the 1950s and 60s, which, as I can explain in a moment, turned out to be suboptimal mentoring. But so we had no idea how to try this case. I remember taking a deposition, my first deposition, and I had defended a deposition of a very experienced lawyer in a tort case. How I happened to be doing that had no business doing it. Anyway, I watched him come in and, with really nothing in front of him, totally eviscerate my client in about 45 minutes, get all the facts that he needed, and walk back out. And I thought, well, that's just how you do it. You just walk in, no paper, no nothing, just, have a conversation. And of course, as you can imagine, this was with the commissioner in charge of the whole department that oversaw these institutions, and I didn't get very much, actually. He seemed to think that everything was fine, and I didn't understand why he didn't, like Perry Mason's adversaries, scream, yes, I did it, and I'd do it again. It's terrible. So our hope was all based that the Justice Department would intervene. Finally, they did. They filed a motion to intervene, and at that point, Judge Morton denied it as untimely, which prompted an early settlement of the case.
But the settlement was not bad. It was good for our clients.
It was.
And it had national implications.
It did. It did. Yeah. It was not what it. I would say that the settlement was good for the times. Our understanding or sophistication about what it would take once we had the decree to move forward and implement it, we didn't have that understanding. And so I think a lot of it did not get implemented as was intended. But it started a movement that began to move the state away from that sort of institutional
and
setting.
In just a few years, there were hundreds of community-based service,
correct,
residential places for
right.
people.
Yes.
But this was not without some repercussions for the lawyers involved.
As I mentioned, the case had been brought as next friends by several young male orderlies that were out at the institution. It was really courageous on their part. They were conscientious objectors. This was during the Vietnam era. This was their alternative service to the military. If they got fired from those jobs, they might have ended up having their status altered in ways that would have been very adverse, to put it mildly. There was also a psychologist who was one of the next friends on behalf of the lead plaintiff, Amy Lynn Seville. She had made such an impression on him, this beautiful young girl. He was really moved by that and wanted to try to give her a life that he knew she would never have at that institution. So the next friends were really impressive. The state was indignant because under state law, when individuals were, quote, volunteered into the institution, then the state became their conservator. And they said, we're the conservator, we didn't give you permission to sue us, and we're the ones who make those decisions. And so they filed, the Attorney General's office filed a motion to strike the next friends, which sounded somewhat assaultive, but however it was worded, the intent was to have them removed, which of course would have had the effect of making the case go away because the clients themselves were incompetent to pursue it. Judge Morton said, we're not doing that. He was a great judge. He cut right to the heart of the matter, and he said, we are not going to deny these people access to the courts, and he denied the motion, whereupon the Attorney General on the case then filed a grievance with the Nashville Bar Association, charging us with champerty and maintenance and some other archaic terms that I still don't quite know what they were.
And back in those days, the local bar association handled the discipline of the lawyers.
That's correct. It was before the Supreme Court took it over. And I have to say at that point it had a lot more to do with guild protection and professional clannishness than it did protection of the public. And I'm proud of the movement that the bar and the Supreme Court has taken in the intervening years. At that point there was a standing committee, but we got some home cooking, and it was assigned to a special committee that was chaired by a distinguished member of the bar who had been very outspoken about his animus towards legal aid, or what was then legal services. And I remember that Larry Woods, private practitioner who was on the pleadings with us, wrote a letter asking we got a citation that we were to appear before this committee and charged with the most serious offenses, and for representing these incompetent individuals without the consent of the conservator. So it was basically a knockoff of what had been tried and failed in the federal court, and with the same intent. And Larry wrote a letter to the chair of this committee and said, who was Dick Lansden, and said, will you please give us the specifics? And the response was, you just tell us what you did and then we'll tell you what you're guilty of. And we did appear before them, and there was toing and froing. I wrote to Jerome Shestack, who at that point was at the American Bar Association, had just started a commission on the rights of the mentally disabled. This, again, was in the early to mid-'70s. It was just beginning to evolve, an awareness of the mistreatment of people with both intellectual disabilities, or as it was then known, mental retardation and mental illness. And I wrote and said, you know, I'm grateful that the bar is recognizing the need for the vindication of legal rights. We have a situation here where the local bar, at least some part of it, is not clear on maybe that's where we ought to be. And that went away. There was a letter that was issued that said that, from the committee, saying that we had been guilty of reprehensible conduct or some such, but we were basically callow youth and allowance should be made for our inexperience and ignorance.
And the Legal Aid Board ought to clamp down on us.
Right, yeah. Yes. But there was background on that, because Brad Reed, who was at Bass, Barry and Sims, was our young board president at that point. He wrote a scathing letter to Dick Lansden, very much his senior.
Well, he wrote to the president of the board, John Hollins. Yeah.
Okay. And said, you know, not only were they not going to discipline us, he was proud of the work that we were doing, and the board would absolutely defend us to the nth degree. And it was a great example of the way that our board and the private bar stood up for us at crucial moments, and really vindicated the notion of equality of justice. And I think Dick Lansden was of an earlier generation, and I think he was an outlier at that point. And
let's reflect about how things were then, and sort of the progress over the years, and how legal aid and now the Tennessee Justice Center have been a part of that process of sort of the coming of age and the maturing of our, we might say the maturing of our legal system.
yeah, I'm very proud of the bar. I'm very proud of legal services for the evolution that's taken place over 45 years I've been involved. I think that, again, when we started, the bar locally was not in a great place. I think it looked at the profession as really sort of a fiefdom more than a way of opening up and serving all parts of the community and guaranteeing equal justice. And that's unrecognizable today. And I think, by the way, I would just put in a plug for anybody who wants historical perspective to read the reported case from the 1940s of the Nashville Bar Association versus Lackey, which will give you a flavor of what the bad old days used to be like, because it wasn't particular to legal services. And when, as you well know, Ashley, because you were responsible for it, when we then in the Carter administration got some funding to expand to other counties outside of Nashville, there was a lot of resistance there as well. But we had our champions, just like Brad Reed, Ronnie Green, Charlie Warfield,
Joe Cummings.
Joe Cummings. In fact, it was Joe's deposition that I watched that made me think, oh, I can do that, which is totally laughable. And you're laughing appropriately because Joe was a fabulous trial lawyer and lots of experience, and yeah, he could do it off the top of his head.
It was in Joe Cummings' office I saw my first fax machine.
So, over that time, the bar has defended us from assaults in Congress. The bar locally has become major donors. The bar has developed a robust pro bono partnership, collaboration. We have partnered with Bass, or partnering right now with Bass, Berry & Sims on an important federal court case. And did, in fact, on the prison litigation. So it's night and day. It really is night and day.
Now, I want to just jump back, just because it's on the outline, just a moment about your education and your early life. One of the articles about you says that the family's religious values and deep Tennessee roots have shaped his career. So just talk briefly about your birth family, where you went to high school, the influences there, and your college.
As I said, I was born in Knoxville, grew up in Knoxville. My family had been there for a long time. My great-great-grandfather was the Reconstruction governor of Tennessee, the only one, incidentally, whose picture is not allowed to be hung in the Capitol because it might scare young school children visiting on field trips. He battled
Brownlow.
Brownlow. He battled the Ku Klux Klan. He saw to it that the state adopted freedmen's suffrage well ahead of the passage of the 15th Amendment. He passed the 14th Amendments, or 14th Amendment, excuse me, here with a good bit of arm twisting. He was a rough cob, but he was colorful, got the job done. I grew up with a sense of being rooted in Tennessee and of loyalty to Tennessee, but also a sense that the state was not what it can and should be. And I grew up Catholic, and that was important to my family. And then I went to high school, to boarding school outside of Philadelphia, and I was exposed to Quaker work camps in the 60s, early 60s, during the Civil Rights era, and I met a lot of the young people who would subsequently go south. And I didn't, during the Civil Rights movement, and I didn't do any of that. I was in high school, and I was privileged, and I was affluent, but it made an impression on me. And then I went to college in New Jersey at Princeton, where my father had gone. But I grew up in great privilege and comfort, and part of that was material, but the most important part was that I was surrounded by a loving family and very secure emotionally setting where I just had lots of love lavished on me by parents, extended family, and could not have been more fortunate. And I grew up, therefore, with a sense that I, had some responsibility to people who did not have all that I had.
And then, in addition to the Catholic influence and the Quaker influence, how did you hear about legal aid, and what was the first you knew about that?
Well, in college, I saw some notice on campus that somebody was coming to recruit for Alaska Legal Services. This was when Legal Services was new, and they were just getting ready to put in the Alaska pipeline. And I remember I went and interviewed with him, and he said, "Well, you're a lawyer?" No, we don't have. In fact, I'm not even clear why he would have been at Princeton because there's no law school there. But in any event, maybe he was just there to speak. But I went. He said, "Well, if you want to come volunteer here, that's fine." But when he described what they were doing, I thought, "Wow, that's something." And I remember him just saying, "We're going to get all this money coming into the state for the pipeline, and none of it's flowing down to the native Alaskans, and none of it's going to benefit the poor people there who need jobs and need training to work on welding and things like that, and that's what we're working on." And I thought, gosh, that sounds pretty exciting.
So that's what, and then
that's what got me interested. And of course, that was at a time when Thurgood Marshall and the NAACP Legal Defense Fund were transforming the law, and out of that, of course, flowed prison litigation and litigation on behalf of people with mental disabilities and gender equality, and all of that was really spurred by the example of the NAACP Legal Defense Fund.
Now, one of the must-ask questions is about military service, and in college you were in ROTC.
I was in ROTC at a time when, and in a place where nobody much was in ROTC unless you were on a military scholarship. This was at a time when ROTC armories were being blown up in places like University of Wisconsin. At Princeton, we were just more condescended to. It's like, why would you blow up the armory? Those people are pathetic nerds. Either that or they're on scholarship. We understand that. So I just didn't get the memo. I was really gung-ho. My family had a military background in my family, and so like I say, I was gung-ho. I subsequently got a commission in the military, and then I fell in love, got married, decided I really couldn't kill anybody, and became a conscious objector. I was thought I would lose my military commission and actually be put into the medics. But in fact, the Army had lots of other things to contend with during the Vietnam era besides some self-important twit from Tennessee. So they just wrote me a letter and said, "You just stay in law school, we'll get back to you." And at the end of law school, they said, "Go report to Fort Eustis, Virginia, to the Transportation Corps, where you'll be trained as a transportation officer." So I went for 3 months branch training, and all that meant that my conscious objector status meant was that when everybody else was out doing weapons training, I was assigned to the driver's course to drive a semi. And I think I spent a week crushing orange cones on the driver course, driving an 18-wheeler around and around. And at the end of 3 months, they seen my potential as a military person, and they said, "Don't call us, we'll call you." I would have owed them 2 years, including regular meetings and summer camp and all that, but by this time it was 72. This is right after I graduated from law school. They had more lieutenants than they could shake a stick at, so I just never got called back. Periodically I'd get a letter, a computerized letter that would say, "Congratulations, First Lieutenant Bonnyman, congratulations, Captain Bonnyman." I think I may have been a major by the time, 8 years later, they finally said, "The prayers of a grateful nation go with you into retirement." It was kind of a ludicrous catch-22 sort of experience.
But so then in March of '73, you returned to Nashville.
And that was when I was hired by Junius Allison, right?
Yeah. And now we talked about the Seville case, and we're going to talk about some other important cases, but you were on intake also at Legal Aid. And you had some other things. You replevied a mule one time.
I did, yeah. There was keep in mind this was the 70s, and so you had older people who were living in Nashville who were, they weren't just the generation removed from the farm. They had grown up on farms themselves and still felt attached. And there was somebody out in northwest Nashville near the prison who had on some little urban lot, maybe a quarter of an acre, a half an acre, had a mule and kept the mule in their garage, but the mule kept getting out and eating other people's vegetable gardens and trampling their landscaping. And so somebody locked the mule in their garage and said, you can't have the mule back until you promise me that you're going to get rid of it. Of course, that was totally unconscionable, and I filed a writ of replevin, as it was then known, and repossessed the mule. And then, of course, the mule got out and did the same damn thing again, and the client came back, and we were having an argument at Legal Aid about whether we should restrict the types of cases that we took. And being young and bumptious, the notion was we'll take all comers, regardless of our total incompetence to represent them effectively, or regardless of whether it's a good use of resources. And I'd been advocating for maybe we should use a little bit of judgment about which cases we took, and I'd said, I'm absolutely refusing to replevy the same mule twice. And that prompted a discussion, as did a name change that I'd arranged fortuitously. Walter Kurtz, the same Walter Kurtz who had hired me, in quotation marks, was a champion of the proposition that we should be all things to all comers forever. And that was he was a great lawyer, and that was his approach to his representing his own clients, but I was less zealous. He also, as part of that, said we were going to be open on Thursday nights to serve people quite reasonably who worked during the day and couldn't get off to come see a legal aid lawyer. That was great, except that he wanted to go play softball, and one night he forgot that he was supposed to be on, and I was about to leave, and people started streaming through the door, and the first one of them was a guy who said, I want a name change, and I said, oh, okay. And name changes was something that I'd been advocating, like mule replevies, that I thought it's honorable work, there's nothing wrong with it. I just think that poor people, probably their higher needs. And we had a form that you could fill out, and if you filed it on Friday morning before 8:30, then you could be on the probate docket at 9.
This is Judge Luton's court.
For Judge Luton. And I'll do the same thing.
Hazard of the modern era. Okay.
And so this young, scrawny guy with long hair, this was during the fading days of the hippie era, but in fact I'd say the hippie era was over, but this particular person had not gotten the message. He shows up, and I sit down and say, okay, what can I do for you, Mr. So-and-so? He said, I want to change my name. Rolled my eyes and said, okay, what is your name now? And I wrote it down and said, what do you want to change it to? He said, TFR Rabbit. I said, how do you spell rabbit? And he said, well, rabbit, like rabbit. And I said, R-A-B-B-I-T? He said, exactly. And I said, and the TFR, what does that stand for? He said, the far reaching. Okay. I'm thinking. First, Walt wants me to replevy the mule the second time. Now he wants me to change this guy's name to the far-reaching rabbit. And then the light bulb came on, and I thought, yes, sir, Mr. Rabbit, coming right up. So I filled out the form. This was on Thursday night, and at 8:15 the next morning, I was at the probate clerk's office with a petition to change this name to TFR Rabbit with Walter C. Kurtz as the attorney. And I came back to the office and said, Walt, you left me over the barrel last night. He said, oh, I feel so badly about that. I said, it's not a problem. It's okay. I took care of it. And by the way, here's your first case. You need to be in front of Judge Luton in 30 minutes. And of course, that was the end of our taking name changes. Anyway, that was one of my early cases. I mentioned earlier that I had my mentor really was Perry Mason, and people will not know this, but the formula for Perry Mason shows in the 1950s and 60s was that, you know, they lasted exactly 24 minutes, allowing for commercial breaks. And during that period, you identified the bad guy and the good guy, and Perry Mason unraveled all this himself, of course, as the criminal defense lawyer. And then, in the final moments, there would be a courtroom drama where the bad guy would be on the stand, and Perry Mason would deliver some bone-crushing question, open-ended, like, "Tell us, who did this?" And the guy would scream back, "I did it, and I'm proud that I did it," and I'd shoot that person again. So, you know, all the things you're taught not to do, except I'd never been taught not to do them, which is don't ask open-ended questions, don't ask questions you don't know the answer to, don't expect the adverse witness to be your friend or give you what you want, etc. So I was doing a child support case in front of Judge Benson Trimble, and child support payments were to be made through the clerk's office, and this guy had not made the payments for months and was in arrears, and all you had to do was just show up as the petitioner for contempt, and the clerk would hand in a record that showed non-payment. So there was no proof to be presented. You just had to show up. And it was always a huge crowded docket. So I showed up one day, and my adversary was an incompetent older lawyer, and he puts his witness on. The clerk, Judge Trimble's courtroom deputy, calls the case. The clerk hands up the record showing non-payment, and so the woebegone defendant takes the stand, and my inept adversary gets him to say he's contrite and he promises to do better going forward. At which point there was nothing for me to do, but again, Perry was my mentor, so I stood up. And keep in mind that there were probably 30 lawyers in the courtroom and a couple of hundred litigants waiting for this humdrum docket, but I was going to spice things up. And so I stood up and grasped the podium and rocked back on my heel and fixed him with a riveting stare. And then I rocked forward, lunged, and pointed at him with my finger and said, "Mr. Smith, can you give this court just one reason why you have so shamefully neglected to support these small children who depend on you?" At which point he said, pointed to my client next to me and said, "Because she shot me and put me in the hospital for 2 weeks and I lost my job." At which point, just like always happened in Perry Mason, my client stands up next to me and screams at him, "Yes, you son of a bitch, and I'd shoot you again."
So, thankfully, you stopped doing child support cases.
At that point, I thought I'd kind of hit my high mark, and I would leave at that point. I then went on to tort defense cases, and I somehow managed to achieve the unprecedented and probably never repeated accomplishment of defending someone who is number 3 in a 7-vehicle chain reaction accident, and making, by virtue of my direct examination of my own client, get directed verdicts in favor of the 2 vehicles in front and the 4 vehicles behind. I think the laws of physics and tort law make that an achievement that is in known danger of ever being eclipsed by another lawyer, but somehow I managed to do it. The worst part was, this was in General Sessions Court, and someone told me, "Well, you know, you can file an appeal and get a de novo hearing," and I didn't know much else, but I somehow staggered to the clerk's office after this cataclysmic defeat and filed a notice of appeal. Of course, the other lawyers are all coming up to me and saying, before I could go appeal, said, "You did a great job, and we'll be real reasonable about working out a payment schedule. But you or Ashley or Walt or somebody said, go appeal the darn thing." So I did that, and a year or 2 later it came up, and meanwhile I remember out hunting with my dad and walking up and down these cornfields and just trying to think, car number 7, car number I couldn't figure out what I'd said or what I'd done. But anyway, the next time I just resolved to not say much of anything else, and truck number 7 or whatever was found liable, the one in the back that rear-ended everybody else. But the punchline was I was representing a young couple and who were in school, and African Americans who really had a hard way to go, and they were impressive young people who were trying their best to make it, and they came out afterwards, and the young woman turned to me and hugged me and said, "Thank you so much. You saved us from prison." So my worst offense was that I'd had these poor souls living with that terror of going to prison, never told them that, of course, you can't be in prison for debt. But then upon reflection, so I felt really terrible, but then upon reflection I thought, well, you know, you couldn't make a car number 3 liable the way I did, so who's to say with my skills I couldn't have sent them to prison. So anyway.
Let's turn to more success. Let's talk about health care, and starting with the collection process for hospitals in the 70s, and talk about the beginning of the Newsom case, Newsom against Vanderbilt.
I had a young woman who worked at Clover Bottom actually as a orderly or janitor, low-wage job, and she had a couple of kids and was really having difficulty. Obviously, she came to legal age, she qualified for her services. And she was being sued by Vanderbilt for the part of the bill that was not covered by her state insurance. And I had done some reading in what was known as the Clearinghouse Review, which was published by the National Clearinghouse for Legal Services, now known as the Sargent Shriver Center, which was, as the name implied, a library resource for legal aid, legal services lawyers around the country. And I'd read about an article about the Hill-Burton Act, which was federal funding passed in the Truman administration after Truman failed to get his national health plan through, sort of his consolation prize. The conservative Democratic or Dixiecrat senators and House people who dominated the committees during the seniority era then said, well, we don't want people to have health coverage, but we don't mind building some hospitals that we can go to and the white folks can go to. And so they passed the Hill-Burton Act, which provided federal fundings that was filtered through the states. It's actually had a Jim Crow provision in it. It's the only piece of federal legislation that actually provided for segregation. Vanderbilt got a lot of money. In fact, they built what was then the existing hospital with those funds. A good bit of the funds were built with Hill-Burton. And it carried with it an obligation to provide a certain amount of indigent care unspecified, and that sat there as a dead letter until legal services lawyers in the early 70s began bringing cases to enforce it. And the Newsom case was one of those cases. And it resulted in a finding that Vanderbilt had taken the money but not provided the free care, and it had to provide due process. It had to, the position was, well, we'll just decide who gets this and who doesn't. And of course, anytime you have that untrammeled decision-making power, you find that bias creeps in, sometimes consciously, now more oftenly unconsciously, but it's what we would now think of as implicit bias. Back then, of course, it was explicit. And so we got a ruling again from Judge Morton that due process, these are public monies, and due process required that everybody be given notice of their ability to apply for the funds, and that there be a process for being heard around that. It prompted the federal government to change the rules. We ultimately lost in the Sixth Circuit. It was reversed, but by that time the rules had gone into effect.
Well, you lost in part.
We lost in part. We lost in part. But we lost the due process ruling, but there was still a finding that Vanderbilt had to provide what now seems laughably small, but given what's happened to health care costs, but they had to provide several $1 million in free care. And we ultimately got them held in contempt because they didn't, and they ended up having to, Judge Morton got so exasperated, he said they had to stamp on every one of their bills, if you do not pay this bill, we cannot sue you, which then prompted a quick trip to the mourner's bench by the sinners, and they got right, and it probably ended up providing a good bit more care than what was required if they'd done it right the first time.
But I think one of the interesting things about the case is, though, it just started out as a routine collection case, just somebody who walked in the door,
Right.
and you tried to settle that with a lawyer on the other side, and you tried to tell him this is a Hill Burton thing.
Right.
He and the collection agency just dismissed the whole thing, and it turned into a federal case. It went to the Sixth Circuit. Yeah. Let's jump over for a minute to the prison case, which also started back in the 70s and then lasted for 18 years.
Right, it ended in 1993. It started in the state court. A number of pro se prisoners had filed through a jailhouse lawyer suit in Chancery Court in front of Ben Cantrell, who was the chancellor in Part 1 here in Davidson County. And he was in his 30s, and he we got contacted by Joe Engel, minister with the prison ministry, who asked us to get involved at Legal Services, brought in Al Bronstein and the National Prison Project of the ACLU Foundation in Washington, and I found that Al was a much, much better mentor than Perry Mason had been. Al Bronstein was a fabulous lawyer. He started practicing in the early 50s. He represented Martin Luther King on behalf of the Lawyers Committee for Civil Rights in several of his scrapes in the Deep South. Just a fabulous lawyer, and started the National Prison Project. And getting to work with him and see what good lawyering was about in our type of law was really a wonderful opportunity. And really, all of us, we didn't all go to Vanderbilt, but we were pretty much litter mates in terms of being young, untrained. There was nobody around to train us, and you know, if you went to General Sessions Court all the time, you went to the child support docket, you know, you didn't get many opportunities to watch really good lawyering in contested cases, at least not on the behalf of the people that we were representing. There were good lawyers who went to General Sessions Court, but most of the defendants were pro se. So getting to watch Al was a great opportunity.
But the effect of that case was pretty dramatic from the beginning to the end. And it just characterized the prison system at the beginning and then the prison system at the end.
At the beginning, the prison system consisted basically of 4 institutions: Brushy Mountain in East Tennessee, which was a former coal mine operated by prisoners, dated to the turn of the 20th century. Immediately after the Civil War, the state started leasing out prison inmates because the 13th Amendment abolishing slavery had a proviso that it didn't apply to convicted felons. And so the state found that it could make money leasing convicts to planters out in the West Tennessee and to coal mine companies in East Tennessee. And when there were riots and an insurrection by free world miners who basically burned down the stockades in the East and set the prison miners free so they wouldn't be competing with free labor, the state then built Brushy Mountain, where they would take the prisoners and work them in-house. And that mine had closed only a couple of years before I became involved. Knowing a little bit about coal mining through my family, I can't imagine how terrible that must have been. I remember talking to a guard who said the air was so bad in that you couldn't sustain combustion more than 100 feet underground. There wasn't enough oxygen in there. Of course, 2 problems with that. One, the obvious one, but the other was, what were you trying to do lighting a match in a mine anyway? But anyway, it was terrible. That was Brushy Mountain. You had Tennessee State Prison, built in 1898 here in West Nashville. You had Turney Center, built in the 30s, which was basically a prison work farm, where you had overwhelmingly African-American prison population from West Tennessee that was being worked under shotguns with guards on horseback. Looked like, you know, something out of a very bad movie. And the conditions were terrible, terrible throughout the system. And then you had Turney Center, which was designed built in the 1970s, relatively new, but terribly designed. And the system, which also included the women's prison, was awful. And in fact, at one point it was the most violent system in the country as measured by the numbers of homicides per 1,000 inmates. And by the time we got to the end, it was the first system to become fully accredited throughout all of its institutions. They closed the state prison here in Nashville under court order, created the conditions where Brushy Mountain, the stuff they had to do to achieve constitutional conditions in Brushy, forced them to abandon that institution as well.
You also want to talk about the Madison Hughes versus Shalala case and some of the other cases that you handled during the time you were at Legal Aid.
Yeah, Madison Hughes was a case that we brought in 1992. I had been involved in a case called Linton, which dealt with racial discrimination in the nursing home industry. It was brought under Title VI. Unfortunately, that's, given subsequent U.S. Supreme Court decision, would no longer be brought today on behalf of private litigants. But we brought the case Linton to deal with racial discrimination in the Medicaid nursing home industry, which was rampant. And it had to do with economic discrimination against people receiving Medicaid, which had a disparate racial impact. That raised my awareness of the more subtle forms, but serious forms of racial discrimination in the healthcare industry, which is significant because Title VI prohibits discrimination in federally subsidized enterprises, and there are more federal subsidies flow into the healthcare industry than any other sector of the economy. And we're all well aware of compliance issues around housing and education and all the enforcement efforts that the courts and administrative agencies have put into that, but nothing had been done basically to enforce non-discrimination in the healthcare industry. And now we're aware, and there's a massive amount of research that's ongoing showing all sorts of ways in which there are inequities in healthcare delivery and very disturbing disparities based on race. But at that time it was believed, well, doctors would never, caregivers would never discriminate on the basis of race. And that, of course, was naive given what neuroscience tells us now about implicit bias that we're not even aware of. Plus all the financial structural issues around discrimination based on lack of ability to pay, which of course correlates to poverty, which correlates to race. And that was the nub of the Linton case, where we showed that if you were discriminating against people who were dependent upon Medicaid, that was a very effective proxy for race. So when we were trying to prove Linton, I realized that there was almost no data available. What little there was an outgrowth, ironically, of the Newsom regulations and the collection of data that came out of Hill-Burton regulations. Compliance reporting that those rules required yielded some very limited racial data. Not that the government did anything with it, but it was totally inadequate. And so the National Health Law Program, the NAACP Legal Defense Fund, and Legal Services of Nashville brought suit against the Secretary of Health and Human Services for failure to fulfill the agency's obligations to collect and enforce compliance data, enforce compliance against the healthcare industry. We lost in front of Judge Nixon here. We lost in front of the Sixth Circuit. But it had the effect, it gave a handle to people within HHS who were concerned about it, and they agreed not to beef up enforcement against the AMA or the hospitals or the nursing home industry, all of which were very powerful in Congress, but they agreed to make data available to researchers by cross-matching racial data in Social Security eligibility files with Medicare data, and it opened up a wealth of research around Medicare that showed that across the board, regardless of the region of the country, regardless of the procedure, regardless, controlling for all other factors, there was rampant disparities in, for example, who received pain-killing medications and who didn't, who received a heart surgical procedure and who didn't, who was more likely to suffer an amputation or wasn't. Horrifying things, really, that nobody was aware of, again, implicit bias. And that came out of Madison Hughes, and really, Madison Hughes wasn't the cause, but it did catalyze give some tools to people researchers who were concerned. It gave them a leg up. And the Affordable Care Act subsequently greatly strengthened the law in that area.
And so even in losing, there
was a Pyrrhic loss.
Yeah,
we lost the battle, but David Satcher, who was the president of Meharry and became the Surgeon General, subsequently told me several years after that it had really been a landmark, even as a loss.
Now, you did legal aid not only here, but also overseas. You had two...
With the same effectiveness with which I handled chain reaction car cases.
Well, first in Israel and then in Budapest. Now, just a word or two about each of those.
Claudia and I, in 1978-79, took sabbatical and went to Jerusalem, where we worked as Presbyterian missionaries. I was raised Catholic, she was raised Methodist, but we got a job with the Presbyterians, who seconded us to the American Friends Service Committee, which had run the Quaker work camps in Philadelphia that had been influential in my high school experience. And they were running a legal aid office for Palestinians in the West Bank. And we worked there in administrative capacity by a set of torture circumstances. I ended up writing a brief for the Israeli Supreme Court on the legality of the Jewish settlements in the West Bank on occupied lands. And at that point, the settlement movement was new. It was understood that it would be a real threat to long-term prospects for peace, and we lost the case. And indeed, it has been a problem.
Yeah. And then Budapest.
Budapest, this was 5 years after the fall of the Berlin Wall, the collapse of the Soviet bloc, and there was an effort by a whole raft of non-governmental organizations in America and in Western Europe to try to help develop former Soviet satellites, including Hungary, to develop a so-called civil society. Under communism, there was no civil society. Even the church was co-opted by the regime. So we worked for a human rights organization led by a charismatic young Hungarian that was dealing with skinhead, extreme right-wing violence, in which the police were often complicit against gypsies and Jews and people of color who had been brought there to attend school during the Soviet era from the Third World, and then when the Soviet collapsed, they had remained, and they were often beaten on the trams and subway and wherever they were seen. It was a very monochromatic society, so they stood out like a sore thumb. And we worked there, and then the organization worked there, Bulgaria, Romania, as well as Hungary.
Now, on that trip, you also took young Houston. You and Claudia by that time had a son.
We did, and he attended a Hungarian school in the in the 8th grade that was taught. It was affiliated with the university, and classes were taught in English. There was a Hungarian class, but anyway, he wanted to go there instead of the international school, and I'm very proud of him. And I think it was very difficult, but it really had a long-term impact on him, I think.
Well, speaking of long-term impact, now in a moment we're going to talk some more about your work on health care, but Houston is now...
In a moment we're going to be out of time.
Houston, break? All right, a moment. Now what... Okay, so I just wanted to ask, in view of all the work you've done in healthcare and the fact that Houston is now a medical doctor in New Orleans, I mean, is there any connection there?
Well, the only connection that I know is that Claudia, my spouse, is also a lawyer and served as chancellor, actually in the courtroom that Ben Cantrell once occupied. And let me just put in a plug for Chancellor Cantrell. He was so courageous as a Republican in a Davidson County, heavily Democratic area who stood to face election. He never flinched in the prison case. And he never flinched in any of the other cases that we took. Great judge, very smart, very fair. Interestingly enough, since a lot of animus directed at legal services came from Republican politicians, great judges that I've appeared before have been Republican appointees. Judge Morton, Chancellor Cantrell, who subsequently, of course, became Judge Cantrell on the Court of Appeals, Judge Thomas Aquinas Higgins, and although not a Republican appointee, Judge William J. or Joe Haynes on the federal district court bench would be quick to claim as his mentors two Republicans, Clure Morton and Thomas Higgins. It's been a great privilege to appear before them and other good judges. I mean, I think I didn't realize how spoiled I was. Really didn't. But anyway, Claudia's had a career in the law, and I think our influence on Houston was, for whatever reason, he said he decided very, very young that he did not want to be a lawyer.
He'd had enough.
Yeah.
So let's talk some more about healthcare, and let's start with the sort of creative financing that you helped work out with the Med that has had such an impact nationally. And in 1980, when President Reagan came into office, and Lamar Alexander was the governor, the state had a budget issue around the Medicaid program. And it was at the same time that President Reagan was, and Republicans were trying to roll back legal services for one thing, but also trying to roll back funding for Medicaid. And so there was a decision made by what was then the Medicaid Bureau, subsequently became TennCare, to cut the number of days, make a number of cuts, the most important of which was to cut the number of days that Medicaid would cover for hospitalization in a year from 20 to 14. And we filed suit under the Rehabilitation Act, which was the predecessor to the Americans with Disabilities Act, alleging that it would discriminate against people with handicaps, that was the terminology at the time, because of course people with chronic illness were the ones that were going to be affected disproportionately by a limit on the number of hospital days. Most people, if they're well, they don't use any days at all. If they do, it's less than 14. So you're really making the sickest people, which correlates to disability, bear the burden of that. We won on procedural grounds initially by Judge Morton.
We got a preliminary injunction, but ultimately lost on the merits of our disability or handicap claim under the Rehabilitation Act. We won in the Sixth Circuit, but then the state petition for certiorari went to the Supreme Court in a case called Alexander v. Choate, the only time I ever appeared in the Supreme Court. And I accomplished, and this is sort of like my experience in a couple of other cases where one never before achieved and never duplicated since accomplishment. I managed to get Thurgood Marshall to author an opinion in a civil rights case in which he commanded a 9-0 unanimous panel or vote in the court against the plaintiffs, in the civil rights plaintiffs, and he authored the decision. So I think I'm the only civil rights plaintiffs lawyer who could say that he managed to lose Thurgood Marshall in a 9-zip opinion. And this was a case when this was at a time when the court led by Chief Justice Berger was very heavily divided. But what I learned from that, other than that I didn't intend to go back to the Supreme Court if I could ever avoid it, was that you know, the budget was all important, that healthcare had been inflating since 1950s more rapidly than the rate of the economy as a whole, and then when Medicaid and Medicare were passed and infused a lot of federal money into the system, that bumped up the inflation ever more. And so Medicaid, which is administered by the states, which all have balanced budget requirements in their constitutions, was growing in cost just because it was purchasing inflating services that had inflating prices, and it was trying to pay for that out of state revenues that reflected the rate of growth of the economy as a whole. And so it was a constant erosion. And for the first few years of the program, which started at the end of the 60s and early 70s, it was at a scale that didn't make any difference, but then the farther it went, then the larger the base against which that disparity was applied, and it just became a chronic problem. And Medicaid cuts were occurring not only in Tennessee, but across states, and it was clear that would continue. And so we were involved in litigation around due process when claims were denied in a case that originally was called Daniels, and then became known as Greer. And that went on for years, and ultimately we, using due process, managed to get a lot of services for people that otherwise would not have gotten them. And I think that's a theme of a lot of legal service litigation, just using due process to say, give people a fair shot, makes an enormous difference in people's lives. But in any event, I had seen that what Judge Morton had done, basically, he'd given us a preliminary injunction, and I think he acted with good legal authority, but I think he also practically, he tended to go to the heart of the matter and what was fair. And I think he saw that it was, that the state commissioner testified from the stand, well, we were going to put these cuts over on the rates, but the hospital industry came to us and said they'd rather be paid the same rates for doing less, so we put the burden over on the patients. And I think he thought that was probably not good policy or the right thing. He gave us a preliminary injunction to see if we could get the politics right, but ultimately it was a political decision that he was not going to substitute the court's judgment for. And it was driven by budget decisions, and of course what I learned was that in that environment, the healthcare providers, although the program is ostensibly for the benefit of the patients, the people that make money from it, the nursing homes, the hospitals, the pharmaceutical, those are the ones with the lobbyists and the political contributions, and our clients were always going to get the short end of the stick. And so I began to be concerned about how do we deal with this escalator that's going to continue to drive up costs and drive down benefits and access. And happened to attend a hearing. I was in Florida for a training with legal services, and there was a hearing going on in Tallahassee in the state capitol because the hospitals were fighting to get, there was a small tax and they wanted it repealed. And kind of the penny dropped, and I thought, you know, we ought to be taxing the services that we're trying to pay for so that the revenue base will keep pace with the cost of the program. Well, there was no possibility of that happening in Tennessee. I did draft a bill and got it introduced, but it didn't go anywhere. The idea was to create a trust fund to pay Medicaid out of provider taxes. And the argument was the providers are going to get it back. So someone who was an adversary in the Medicaid agency, Steve Reed, who I dealt with in negotiating the implementation of some of these other due process decrees and had come to respect, called me up and said, I just read about a new regulation that the Reagan administration had put together because they were all for private charity in lieu of government programs that would enable people to donate to their Medicaid programs, and the federal government would match that, treat that as bona fide state revenues which could be matched. And of course nobody in their right mind is going to write a check out to the state government for the Medicaid program, but the penny dropped at that point, and I realized, wait, we could get hospitals, never mind the fight to pass taxes, we could get hospitals to make donations that would then enable them to get money back through a program called as disproportionate share hospitals, which could enable the state to make block grants to particular programs, hospitals that served disproportionate volume of low-income and Medicaid patients. So I went to Charlotte Collins, a former legal services lawyer and colleague who was then counsel at the Regional Medical Center known as the Med, which had formerly been known as the City of Memphis Hospitals, and talked to her about it, and she convinced the Med to start making donations to the Medicaid program. Meanwhile, Governor McCoy had been elected, this was like 88, 89, and learned about this at the end of the Reagan administration. They came in, I met with David Manning, who was the incoming finance commissioner, and said, look, you're in a hopeless position. Medicaid is now a significant part of the budget. It's inflating more rapidly, as you know, than the state revenues. It's either going to cannibalize the rest of the budget, education and so forth, or you're going to have to keep raising taxes, neither of which is very appealing. But, you know, it's like the old saw. If you're hiking in grizzly country, you don't have to outrun the bear because you can't, but you do need to outrun your fellow hiker. And in this case, you can't outrun healthcare inflation, but you can outrun the federal government, and this is how you do it. And so the Med started making donations, Nashville General Hospital started making donations, basically convinced the counties, which were subsidizing them, give the money to the state and let them match it with federal money 2-to-1, and then give you back your money through disproportionate share payments, block grant payments, and then the state can, the first year it was used to expand coverage to pregnant, low-income pregnant women and infants. And that went through iterations. The feds disallowed it, and Legal Aid filed on behalf of the Tennessee Healthcare Campaign, a nonprofit advocacy organization that we were involved in starting, filed an amicus brief before the Departmental Appeals Board in an administrative proceeding, and the board, citing the legal services brief, upheld this. And subsequently, other states started copying it. The law evolved. We passed hospital tax to extend it across the industry. I read that it's estimated that in 2015, $44 billion in federal funding went to Medicaid programs through this mechanism. Every state now does it except Alaska. And I cite that just as an example, and it staved off what would have been a continuing erosion of the Medicaid program. And it grew in our state to the point where in 1994, at the end of his administration, 93, Governor McWhorter and David Manning and then Medicaid Director Manny Martins put together a plan called TennCare, where they went and negotiated a waiver with the Clinton administration to take this, what by then was a very large amount of federal money that was being leveraged and going back to the hospital as part of it as disproportionate share hospital payments, to say, look, why don't we convert that into Medicaid cards for, instead of it going as largely unaccountable money to the hospitals, let us cover people, and they covered, it was the largest increase in coverage of any Medicaid program, and the largest reduction in the number of uninsured indigent people in any state.
But you and David Manning and Manny Martins worked on that a long time together.
It was David's brainchild. Manny was the great administrator that could figure out the nuts and bolts of taking a concept and making it happen. And David called me up, and he had been talking to Governor McWhorter and said, you know, the governor's heart's in the right place, and he's very shrewd, and he's a numbers guy, but he's also a people person, a genuine politician who cares about the stories. And I need for you to provide, by this afternoon, 3 people, clients, who can close this deal with him. And one of them was Pam Cardozo, who was a paralegal at Legal Aid, had a child with special needs. She called up a couple of her friends. These 3 women went over and talked to them about what Medicaid meant to them and to their special needs children. And afterwards, David called me up and said, I don't know how you did that, how you found them, but they moved the governor. He's on board. And in fact, he was so moved that when he announced at the General Assembly, he had Pam Cardozo and her son, Sammy, come and stand with him in the well of the house up at the state capitol to announce the program. So it was an example of legal aid doing the kind of lawyering that full-service law firms do, of looking at the finances, looking at the intricacies, working the deals, but also having the relationships based on our caseload, based on our staff. Our mutual pastor, Bill Barnes, used to say, if you want to be authentic about serving people at the margins, stay close to the victims, and legal aid stays close to the victims. And that was an example where the micro and those micro relationships with individual clients and staff really moved the needle for systems change. And TennCare served for about a 7-year period before it was cut in the Bredesen administration for reasons that had nothing to do with its merits. Served hundreds of thousands of people, working people who would not have qualified for a regular Medicaid program. As I say, that financing mechanism that originated with Steve Reed, who was an adversary, but with whom we had a mutually respectful relationship, and a shared goal of making government serve constituencies, including people that did not have political clout. It came out of those relationships.
Let's change for a moment in the just few minutes we have left to an institutional issue in 1996 and the beginning of the Tennessee Justice Center. Why don't you just tell what happened? One person described that you stepped off into a void, not knowing what would happen then as results of some things that had happened in Washington with the Legal Services Corporation.
So in 1994, there was a Republican sweep of Congress. Newt Gingrich became the Speaker. He had what he called the Contract with America, multi-point program of reform, one of which was to abolish federally funded legal services. It passed, but then it got held up in 95 in what was the shutdown, the confrontation between him and President Clinton. But the handwriting was on the wall when the Senate passed funding. It didn't completely cut it off, but restricted what federally funded legal services programs could do with any of their funding, not just their federal funding, but couldn't handle class actions, couldn't handle cases where there were attorney's fee awards provided by statute, couldn't represent people in certain types of welfare cases, people who were incarcerated A lot of
no legislative advocacy.
no legislative advocacy. So a lot of that work, full service work that we had been doing was now going to be, I mean, fortunately, legal aid would survive and it would continue to do good work, but those controversial parts were now taken away. And I didn't step off into a void because you and Ronnie Green you worked the other legal services programs across the state, their leadership. Ronnie worked with the private bar, and if there's no better testament to the transition or the transformation of the bar over a 25-year period than the contrast between our difficulties in the early 70s and where we were in 95, 96, less than a quarter century later. Under Ronnie's leadership and yours, you all called a summit in October of 95, again, when the handwriting was on the wall that legal services would be restricted. Harlan Dodson, Stuart Clifton incorporated the Tennessee Justice Center. I made a decision that I would leave to do that work, to continue on the cases that were going to be orphaned. Michelle Johnson, who had a fellowship, against my advice, insisted on coming with me. And you all had persuaded the Tennessee Bar Foundation, again, more evidence of the leadership of the bar, to reserve some funds from the interest on lawyers' trust accounts that would have gone to legal services, but legal services programs under your leadership selflessly agreed that some of that should be held in reserve to fund the Tennessee Justice Center, this new entity. So we stepped off. We didn't get funding immediately, but we were pretty confident that there would be Bar Foundation funding, as there was. And the Tennessee Justice Center since then has been doing that work that could not be done by legal aid. But we still see ourselves very much as complementary and collaborative in those relationships.
Well, and have really handled some significant litigation ever since then, mostly in health law.
Yes, we inherited cases involving TennCare, what by then was TennCare, involving due process, involving children's services, involving the care of people with mental disabilities, involving nursing home, due process around nursing home coverage. So really a continuity. The state at one point complained that the Tennessee Justice Center had required the state to spend $2.5 billion on services that it would not have otherwise provided for medical services. So I'm proud of the work that TJC did, but it really is a continuation really of the work at Legal Aid, and it's very much a reflection of your leadership and Ronnie Green's leadership.
Well, but now you and others on the staff have really, I mean, you've not only handled significant cases, but you've amassed tremendous resources in terms of the co-counsel that you have.
And I credit Michelle with that, who's now the executive director, is a terrific, I would say, charismatic leader and manager. And she recruited large firms, Kirkland & Ellis, Sonnenschein, Nathan Rosenthal, which is now known as Denton's, which is the largest law firm in the world. She recruited them to help us with the John V. case, which was the children's health case, and with the due process cases, Greer. We also got help from Southern Poverty Law Center, from National Health Law Program, National Center for Law and Economic Justice, Burr and Foreman, Bassberry and Sims. So we could not have accomplished nearly what we've been able to do without the collaboration of those colleagues. And in fact, at one point, Kirkland & Ellis and the firm now known as Denton's, between them, over a period of intense litigation during the Bredesen administration, expended $16 million worth of pro bono resources on our co-counseling with us. This is during a period when the state had gone out and hired 5 DC firms to oppose us in those cases. One of those firms had been paid $25 million on our cases. So we would have been rolled as a tiny little nonprofit. We would have simply been rolled. But very much thanks to the collaboration of the private bar, that didn't happen.
Well, and these were complicated cases. One of your co-counsel, pro bono, said that the case, and I think he was referring to the John B. case.
Right.
This is Robert Joseph, who was former chair of the ABA section on antitrust law, said that...
And a great human being,
yeah,
and a great lawyer.
Had been doing this for 38 years, said that your case rivals any antitrust matter in my experience, whether viewed in terms of overall strategy, legal issues, discovery, or management. I mean, so this was complicated. So the John B. was really a quite involved case.
It was. It had to do with whether the state was meeting federal quality of care standards for 700,000 children on the TennCare program, ranging from well child visits, prenatal care, to very complex care of children with severe behavioral health, mental health issues, and very profound deficits. So it was very challenging.
Now, we've just got a couple of minutes left, but talk about some of your relationships with clients over the years and what it has meant.
Well, Michelle and I sometimes use the phrase ironically on tough days, but we, at one point after an interaction with a client, we said, we're the luckiest lawyers in the world. And I think that speaks for legal services, all of us who do this work. We get to serve people in moments of crisis. They allow us into their lives. I don't think poor people are any more noble than the rest of us, but adversity does tend to bring out the best in people, or the worst sometimes, but the people who come to us are so often heroic and courageous and care very much about other people. I learned that in the prison case. It turned things upside down. We had people who were in prison for heinous crimes who still had a sense of a real moral core, and they were coming forward at risk of their lives to speak about corruption and violence. And meanwhile, the free world people, who are the ones gaining respect in the larger society, were guilty of perjury and corruption, and in some cases literal violence, setting convicts up to be set upon by other inmates. And I just realized, these artificial categories that we all subscribe to socially about who's up, who's down, who's good, who's bad, who's other, who's us, are artificial. And it has been a gift to represent clients who have inspired me over and over again for 45 years. And really, along with wonderful colleagues, enable me to keep going and want to keep going.
Thank you.